Hi everyone. I'm going to teach you today on the um, topics of the constitution of the company under Malaysian company law. I hope everybody has read these notes I've given. In fact, I expect all of you to actually do your own reading prior to this lecture. Okay, for today, you are expected to know that after we finish this lecture, you should be able to explain the constitution of company, discuss alteration, as well as discuss the contractual effects of constitution. So this is what we're going to do. We're going to look into evolution of the constitution from Companies Act 1965 to Companies Act 2016. And then we're going to look into the provisions under Companies Act 2016, alteration and legal contractual effects. Okay, but basically we're going to do this first before this. Okay, all of you have known that this Companies Act 2016 is the new act which replaces a lot of things. They have actually amended a lot of things. So basically, under the Companies Act 1965, there's MOA is what we call Memorandum of Association. And AOA, Article of Association. So we're going to call it MOA and AOA. So MOA spells out the object of the company, what is the purpose or essential details of its existence. So basically, it gives the fundamental basis of the company, define the structure, aims of the company, as well as members' liability. The other one, AOA, is a set of regulations for the management. It governs day to day, and it also looks into what can the member do, what can the director do, what are the provisions or procedures on transfer of shares, on transmission, everything, on dividend. So basically, it's more of internal regulation. So previously, under the Companies Act 1965, MOA and AOA are the constitution of a company. So basically, MOA and AOA are public documents. Okay, the public can actually access through. You have to go through this official search at the CCM. Okay, and then you're going to get a copy of their public document. So these are the things under basic things that you need to know under the 1965 Act. Now, subsequently, when the new Act came in, Companies Act 2016 removed the mandatory requirement for a company other than company limited by guarantee to have a constitution. So basically, previously, under 1965, all companies must have. But now, under the Companies Act 2016, it's optional. Okay, it's no longer mandatory. But company limited by guarantee must have a constitution. Why? We have seen that company limited by guarantee are public companies. They do more for charities. They do more for recreational. So they must have a constitution so that people actually look what are the things they can do and what are the things they cannot do. So I would suggest you to have a look at the SSM website. You can download a copy of the constitution of a company limited by guarantee. So all company limited by guarantee will follow that particular constitution. Okay. Now, for existing companies which registered under the Companies Act 1965, basically with the coming of 2016, their MOA and AOA remain valid and enforceable. Okay. So basically they can still use it, but now it is best that they adopt their MOA and AOA as constitution. They must have special resolution saying that they are adopting the MOA and AOA as the constitution, and they must lodge it within 30 days from their adoption. Right? Now, if possible, that before they adopt, they must look at all the important provisions under the MOA and AOA to ensure that nothing in the provisions actually contravenes or inconsistent with Companies Act 2016. Otherwise, those provisions would not take effect. Okay. Now, you must pass whatever amendment to be in line. You must actually check that those provisions under the Constitution should be in line with the Companies Act 2016. Now, if you have a shareholder agreement, which is an agreement among the members, okay, or any joint venture agreement which you entered under 1965, you should actually relook so that it would not actually inconsistent with the Companies Act 2016. So it's best that you look what are the importance as well as in line with the current statutory provisions, right? Now, if the existing company decides to revoke MOA and AOA by right, and if they don't want to have any specific constitution, they wanted to rely on that particular act, 2016 act, they must also pass a resolution. Okay, so basically, if you have no constitution, so company directors and members, their rights are as set out in the Companies Act 2016. Okay, now under certain circumstances, if this is on debate, on legal debate, company limited by shares actually required to have constitution. Why? Particularly when the company has a different classes of share, right? Because when it comes to different classes of shares, so by right, those classes of shares, basically they're going to put in what are the rights that attach to those shares. So when a company, private limited company, or any company limited by shares, it can be public or private, if you have different classes of share, it is best to have a constitution. At least the rights of the members are enshrined in that particular constitution itself, right? Now, although private companies are not required to have constitution, okay, but there are also issues which we're going to talk later on the transfers of shares. So basically, if you look later, that under section 42, company actually are restricted, shall restrict the transfer of shares, so that you cannot just simply selling off your shares to outsiders, right? Because we have this private limited company are very unique. It should be maintained within that particular members of the company. I put up in the notes why it is advisable for company limited by shares actually to have a constitution, because under section 106, by right, whenever a company receive a document to transfer of shares, they must actually do so. They must actually allow the transfer unless the act or the constitution itself prohibits such transfer. We're going to learn later more of the section 106 on the registration of transfer later when we do our topics on shares. But I put up notes to that effect. You can actually read and try to understand. Okay, next. Now we're going to look into the contents and form and contents of constitution. Now, section 34 provides that constitution is the document adopted. Now, basically, it is a document which sets out the rights and liabilities of members, right? So these are the things that stated under section 34. Okay. So basically, section 34 itself explain what does it mean by constitution. So if it's a company limited by shares, something that you adopted as constitution pursuant to section 32. Okay. If it's a company limited by guarantee, it's also a document lodged. Document lodged to the registrar pursuant to section 38. Or depends if it's registered previously under the 1965 Act. So basically, those are what we call a constitution. These are basically what does it mean by constitution. Now, what does it contain of? Right, these are governed by section 35. So basically, constitution should contain the objects of the company, capacity, rights, powers or privileges of the company. okay, if the provision restricts such capacity, rights, powers, and privileges, or any other matters contemplated by the Act to be included in the Constitution, or any other matters as the company wishes to include in its Constitution. So basically, under the new Companies Act 2016, companies are no longer restricted with the object clause. Now, previously, you must put your object clause. What is object clause? Object clause is a clause which says that what type of business you are doing, right? So if you register your company as a furniture manufacturing company, then you should restrict your business to manufacturing furnitures. If you go beyond the object clause, basically you are ultra virus of your particular power. So that will be under the doctrine of ultra virus. Okay. Now, under the Companies Act 2016, you are no longer restricted by object clause. Now, if you go to SSM, you register, normally they're just going to ask you what sort of business, right? So you are free to actually engage into some other business if you feel that this sort of business doesn't work it out. Why they allow it under the Companies Act 2016? Because previously it's so difficult to change business in event of economic downturn. Now, if we look at current situation, coronavirus disease happens in happens in 2019. So this is why we call COVID-19. So during this period of pandemic era, it seems that a lot of business has actually suffered economic losses. So if they wanted to change their business, they have to go through certain procedures which may require approval by the shareholders. So when they do away with that particular object clause, so the business can actually move from one type of business to another. But it's also best that they inform their shareholders, because shareholders are the investors for the company. So there should be check and balance of doing business. So the director must not simply just change business, but they must justify their action of changing business. Okay. Now, even if there's no more object clause, but if the company decided to have an object clause in their constitution, that particular company is restricted from carrying out any business activity not within that particular object. Okay, you are not allowed to go beyond your powers. Okay, with this Companies Act 2016, there's no more doctrine of ultra virus by right. So previously there was this section 20 subsection 1, Companies Act 1965. They validate the ultra virus transaction. So now if the company still maintain the MOA LOA, so any matters relating to object clause will follow the common law decision. So if you go beyond your own object clause, that particular business transaction will be void and it will not bind the company. I suggest you look at case of Ashbury Railway and Iron. You can actually look at the internet for this case. Okay.